Hello, everybody. Have a seat, please. Can you close the door behind so that we are in our intimate courtroom? Why a mock trial? I was wondering the question, and I just thought that why they ask us to do a mock trial at ECTA conference. But in fact, we should always do a mock trial before our real litigation, because mock trial help us to fine-tune our strategy. It helps us to better understand the case, the formatting of the presentation, the strength and the weakness of our case, and also it helps us to just feel better confident the day of the real trial happened. Here today we have built up a fake trial because we don't want to involve any of our clients and be sensitive issue about anybody in the room. And of course, taking into consideration the limit of time of our presentation, we will have a limit presentation of our argument. And we are somebody maybe thinks that, oh my God, what are they awful legal argument are they presenting? But it's a little bit the show, so forgive us. In the real life, we are really perfect lawyer. And so I would say a word. So I'm here, I'm the plaintiff. I like to complain. And I have my great opponent. She's Noemi Parotta from the Italian law firm from Spherian. I don't know how you say it. Spherian. They just changed the name, so remember it's Spherian. And we have also the great pleasure and honor, really, to have a real national judge today. And it's Camille Lignière from the High Court of Paris, who is specialized in IP and who will help us to solve the issue. So let the battle begin. A little bit quack.
All stand, the Paris court is in session.
Good afternoon. Please be seated. First case on the docket is Colette SARL versus Giulietta and Zeus.com company. Maître Motet.
Oh, we are ready, my president.
Maître Parotta.
I'm ready as well.
Thank you. In some jurisdictions, the judge requires the parties to first read their respective claims. But there, I shall proceed like in my French court. So, before giving you the floor, Maître Motet and Maître Parotta, I shall summarize what I understood as being the undisputed facts and legal issues. Concerning the undisputed facts, the plaintiff is a company, Colette SARL, established in France. Its registered office is located Avenue Montaigne in Paris. The company is worldwide famous in the luxury fashion field. Since the 2017 autumn-winter collection, Colette Company commercializes a bag which is named Colette Classic. In order to sell the bag, the Colette company has registered a three-dimensional trademark at the UIPO on the 13th April 2017 under the class 18 for leather bags. So you can see the first bag. It's our registered trademark, but without Colette, the verbal term, just the two dots. The Colette company has noticed that in July 2017, a bag with a sign which is, according to Colette company, similar as its own trademark, is sold on the online marketplace Zeus.com. So it's the second one. This website is in English and owned by a company, Zeus, established in Athens, in Greece. On this website, we can see that the litigious bag has been designed and manufactured by a company established in Milano, in Italy, named Giulietta. The plaintiff has bought online one of the litigious bags on Zeus.com, which has been delivered in Paris. On September the 5th, 2017, the Colette company brought a civil action before the Court of Paris against the Zeus and Giulietta companies for infringement of its trademark. Concerning legal issues we have to deal with, first, the issue will be about jurisdiction. The question is, has the French court jurisdiction while both defendants are established respectively in Greece and in Italy, and while the website is in English? Second issue, we need to address the question of the validity of the Colette Classics trademark, which is contested by the defendant. We will focus on the particularly tricky issue of the distinctiveness of the three-dimensional trademark. Then, concerning the infringement in itself, we will try to define who is responsible, the seller, and the owner of the website, the designer, and the manufacturer, or both of them. Last but not the least, the final issue will be the scope of my judgment. Can the plaintiff request a pan-European injunction, as well as monetary compensation for the damages suffered in the entire EU? Maître Motet, thank you for your explanation about all these issues, but I suggest that you each deal with an issue before we pass to the subsequent one for the clarity of the debates. Are you agree about that?
Thank you, Madam the President. Of the record, the Battle of Ares. Of course, the courtroom is like a court of battle of argument. And I learned, in addition, that Ares was also the god of civil order and courage. And I must admit, when I see this case, I must have a lot of courage to defend it, don't you think? So, back to our... Madam the President, first issue to be discussed is the jurisdiction aspect. And there, we obviously facing an infringement of an EU trademark, and as an EU trademark court, you have obviously jurisdiction. Regarding the international jurisdiction, one has to refer to Regulation 1215, 2012, on jurisdiction of recognition of enforcement and judgment in civil matter due to the transfer and implementation of different member states. I know and everybody knows that it's a common rule that the defendants before a court of a member state is sued before the court of the state where he is his domicile. And I know that obviously here it's Italy and Greece, but the regulation provides for a set of special jurisdiction rules, and obviously that apply in the matter. Indeed, Article 7.2 of the regulation states, a person domiciled in a member state may be sued before another member state in matter relating to tort in the court of the place where the harmful event occur or may occur. And in the present case, the harmful or the damages, of course, occur also in France. In fact, it occurs all over Europe, but specifically in France. And as you mentioned in your summary of the undisputed fact, Madame the President, my client proceeded with the purchase of the legitimate bag in France, and those bags were delivered in France, and the invoice was sent in France and paid in France. And so despite the fact that the Zeus website is in Greek and in English, obviously it's also accessible from France, because you have sometimes some website where if you are, like, for instance, at the beginning, some years ago, I wanted to buy some Repetto on the website, the Repetto French website, and even if I was 1 hour from Paris, I could not. So there is a possibility, if you do not want to serve all the European consumer, that you can prevent by tools, electronic tools. But here, no. Even if the website was in English and in Greek, a French consumer and everybody can order it all over Europe. So, according to the ECJ case law, this suffices to grant redirection to your court. I refer notably to the decision of the Court of Justice of 22 January 2015. I have prepared for you a little set of all case laws that I'm referring to in my brief, and also to help you, I have outlined with some sticker the important part of the judgment, because of the record, I know that usually judges are lazy. Back to my pleadings. And according to this case law, so this decision in PES Actus versus Energy Agentur, there is no need for the website to target the customer of the member state where the relief is sought. And I pointed out, and I put it in yellow for your easiness, paragraph 32 states that, specifies that the Court of Justice specified, Article 5.3 of EU regulation, which become 7.2 of the new regulation, does not require the activity concerned to be directed to the member states in which the court sees is situated. So, obviously, you have the jurisdiction. Of the record, I maybe not say that the judge was lazy. It's not good for my argumentation, so that in the real life I will never say that. And then, in addition, but I'm not going to tell the judge neither, the French courts are, in fact, the most favorable to this kind of proceedings. In fact, I just checked on Dart IP. I'm not sponsored by Dart IP, don't worry. But on Dart IP, there was 87% of the French court decision that have ruled into my favor. That means in favor of 3D decision for bags, trademark for bags. But I must admit, and there it's really off the record between us, so that my opponent and the judge do not listen to it, only 13% of the decision as regarding 3D trademark for bags as admitted the inherent distinctiveness of the bags. So it's not really that good for me. And, but in any case, I must admit also of the record that Dart IP has really helped us and changed our everyday life in preparing our case and in our strategy. So let's back to the real court case. I'm done with the jurisdiction case, Mrs. President, and of course I reserve my right to reply to the defendant argument.
Thank you, Maître Motet. Defendants?
Off the record, in my real life, I usually represent brand owners which face infringement. So, you know, like this mock trial was kind of challenging to me because when they required me to defend the defendants, the bad guys, I was like, oh no, I have a very bad case. But you know, like, litigators have something inside. So as soon as you start studying the legal issues of the case, you get convinced that you are absolutely right. So now I think that I have a very, very strong case. So let's go to the first issue, which is jurisdiction. So, Madame the President, first of all, I want to say that my appearance today does not mean that I accept your jurisdiction. Even if I'm going to put forward substantial arguments, I'm here, first of all, to challenge your jurisdiction. So, about jurisdiction, the plaintiff based this action on the special rule of jurisdiction of the locus commissi delicti. In the defendant's view, in the plaintiff's view, this jurisdiction is based on regulation on the jurisdiction and enforcement and recognition of civil and commercial judgments, and the plaintiff expressly referred to Article 7.2 and to some case law concerning the application of this article in copyright cases. According to Article 7.2, the locus commissi delicti is the place where the harmful event occurred or may occur. According to the established case law, this could either be the place where the damage occurred or the place where the event which gave rise to the damage was put in place. However, here we are not talking about copyrights. We are talking about UTM registrations, and we have like specific set of rules in the UTM regulation. And first of all, with respect to Article 7.2, the UTM regulation expressly ruled out the applicability of this article in case involving UTM registrations. Secondly, the rules to establish the locus commissi delicti, according to the regulation, is the member state where the act of infringement has been committed. And according to the judgment of the Court of Justice in the Coty decision, this is a criterion completely different, not really completely, but it is something different from the criterion which we have in Article 7.2 of the regulation on jurisdiction. Because in this case, we don't look at the place where the damage occurred, but we look, the linking factor is the active behavior of the person who carried out the infringement. So actually, we don't look at the place where the damage occurred, we look at the place where there is the active act that gives rise to the infringement. With this principle in mind, let's look at the position of my clients, the manufacturer. The manufacturer is Giulietta. Giulietta is based in wonderful Milan, and Giulietta carries on is in charge of the design and the manufacture of bag, and specifically of the contested bag. So Giulietta active conduct is the manufacturing process, and the manufacturing process took place in Italy. So this court, my president, does not have jurisdiction over the manufacturer. Let's look at the guy, the Greek guy, which is the owner of the website. Okay, it might be like the active conducts are two here, because we might have two kinds of infringement: the offer for sale and the actual sale. So in this case, as often happens with online, with e-commerce, my client does own the website, but a company related to my client, which is Zeus International Trading is in charge of the e-commerce activity, which means the payment and the delivery. So this company was not involved in this case. So this act of infringement is not, does not belong to my client. So with respect to the place where the bag was delivered, there is not jurisdiction either on my client. Let's look at the offer for sale. So as like my client owns the website, he puts on the website the images of these bags, and it carries on advertising activities of this bag. But again, we are talking of a website which is entirely in Greek or English, which does not target French consumer. You know, like French people are really, they don't like English. Anytime I go to Paris, I find like myself posing questions in English, and like I receive like French answers. So I mean, like, I doubt that French consumers will buy anything from a Greek website, which is either in English or in Greek. Lastly, the active conduct in this case is putting the different products, the images on the website. And this was done in Greece. So this court does not have jurisdiction even like on the seller position. So I think that this action should be dismissed for lack of jurisdiction with respect to both the Italian and the Greek defendants, because the jurisdiction is either of the Italian courts or of the Greek courts. I'm done.
Madam the President, if I may just quickly reply.
Please.
I would like to point out that, in fact, in terms of international jurisdiction, the fact that the case law to which I refer concern copyright, it doesn't matter, because the principle, it's a tort action, and the principle are the same. And obviously also there is a connexity between the two claims of my client, and the more obvious proof of that is that the defendant are just represented by one single lawyer, maybe for cost-effective reason, but and here, especially because of the timing issue. So I hope, Madam the President, that your wisdom will be then not to pay attention to the wasical argument of my opponent.
Thank you for your explanation. I would like now to hear you on the merits of the case, and in particular on the validity of the EU trademark of the claimant.
Madam the President, here we have an obvious, I will go back to the trademark. So the first picture is a trademark as registered without the Colette name and the other one. And obviously the Giulietta, also Colette, Giulietta, I mean, I didn't go into the details in my argument, but obviously there is a kind of attractive to the reputation of my client. The bag reproduces all the characteristics of the Colette classic trademark. It's almost a Slavish imitation, beside the dots and the length of the handles. No attention should be brought to these small differences. What counts is the global impression left on the customer, and in addition, the latter will never be confronted to the bag in comparison like we have to do. In the real life, they will see the Zeus bag, or they will see the Colette bag. So the customer would obviously believe that these bags are coming from the same origin, the same color, the same shape, and so obviously there would be confusion. The only argument that the other party is able to raise and to challenge the validity is the validity of my client trademark. But my client's 3D trademark is not devoid of any distinctive character. It has distinctive character. I refer in that respect, and again, it's in my little folder with sticker to outline the important decision. The Court of Appeal of Paris has recognized numerous validity of 3D trademark represent famous books such as the Birkin of Hermès, the Knopf of Bottega Veneta, and the Colette Classic registration is just similar to these books. I mean, it's a hit bag with a specific shape and pure aesthetic representing the minimalist approach of new designer, a triangle basis, round with thin handle. Did you notice? Okay, I know that but you will see in my folder you have all the detail and the real registration, which is more clear than on this slideshow. And also the two dots, which are also very specific. And so the overall impression of these, it's distinctive from usual form of leather bag. And I don't know here in the audience if there is any ladies who has such a bag with such a white colored blue dot or very similar. I mean, most of the bag, but I should hide mine and I should hide the one of Hector. So, in fact, it casts the attention of, it's not the usual form of a leather bag. I mean, who will ever have a white bag? It's getting dirty very easily. And so it catches the attention of the average consumer so that it's perceived as an indication of the commercial origin of the bag. It has thus a distinctive character. And I would like to point out the criteria to appraise the distinctive character of 3D trademark should not differ from other trademark, and contrary to what I read in the pleadings of my opponent, I mean, we have to stress the fact that the consumer does not usually perceives the shape. I know that the consumer, and there is case law about that, the consumer does not perceive usually the shape of a product as being an indication of origin of such product. But here we should keep in mind that the average consumer, so the average consumer is not the stupid consumer. The average consumer is well-informed consumer, is reasonably observant. And here, especially in the fashion industry, you have the fashionistas, and they are fond of the bag. And I know that, I mean, like Colette, they have on Instagram more than 3 million followers, and so it's really well known. It's comparable to Hermès or Gucci or Prada bag. So it will be on a very, very, very subsidiary order that I will address the issue of the fact that in case you would consider that this bag is not distinctive, this registration has no distinctive character, I will rely on my other exhibit that I have here, bring to you, sorry, it's quite heavy. But here I have, in any case, at very strict subsidiary order, I brought some evidence that my trademark, that my client's trademark has acquired distinctiveness since surely its registration. And I put evidence about France, Germany, Italy, Spain, even UK. But I must admit, I don't have any evidence from Serbia. No, it's not part of the EU. I don't have, not yet. I don't have any evidence from Croatia. And I know that my opponent rely on established case law, but I found a decision, and it's again in my folders, that it does not require such, it's avocat général, I don't think it's a decision, but it's a little bit absurd to require evidence in each single member state, and such interpretation of the law, it's a little bit against the unitary character of the law. unity character of the EU trademark. So that's why I would say that it has distinctive character, and in any case, on a strict subsidiary basis, it has acquired such distinctiveness. I leave the floor to my opponent.
Off the record, in real life, I don't really agree with the case law I'm going to rely on. Actually, I mean, like, I really hope that at some point we will have like a different case law on acquired distinctiveness. But here, you know, like, again, the litigator, which is in me, you know, now I kind of like this case law because it makes my case stronger. So let's start with my counterclaim of invalidity. Madam the President, I mean, I followed the suggestion of the court to upload all the documents online on your platform. I mean, I'm part of the paperless generation, so I don't have any file with me. So, anyway, starting with like, here we have a
She make a point.
So, we are talking of a shape of a bag. And all of us knows how the case law is very strict when it comes to the distinctive character of shape trademarks. This is because our case law believes that consumers are usually not accustomed to see, like, to perceive shape trademarks or packaging as something which has a distinctive function. So our case law requires, I like to say, like a very high threshold to establish a distinctive character of shape marks, because it requires that the shape departs significantly from the norms and customs of the relevant sector. And come on, let's look at the other side bag. The other side bag, great, thank you. So here we have like a very standard shape, which is a common shape that you will see whenever you go to a store buying anything. And the very fact that this is like a common shape for paper shopping bags does not mean, and not for leather bags, is not enough to make this shape distinctive. Because again, the public will not see this bag as like being distinctive. And the fact that this bag has spots, blue spots on it, does not make any difference. We are talking about very simple geometrical shape, circle. And there is also an established case law of which says that simple and banal shapes are not perceived as a trademark. So the addition of something which is not distinctive to something else which is not distinctive either does not make the trademark distinctive. So I really believe this is like a case where we have a trademark which is not inherently distinctive. Let's turn on the acquired distinctiveness issue. We all know that nowadays, if you have a shape mark, good luck. It is virtually impossible to establish acquired distinctiveness within the European Union, because according to our established case law, which bases are the main principles you can find already in the stock decision, when you have to establish the acquired distinctiveness of a trademark, you have to provide evidence for the member state where your trademark was ab origine invalid, so without distinctive character. But again, like the perception of the public with respect with shape trademarks is assumed to be the same throughout the European Union, which said, with other words, means that we are required to provide evidence for each member state, which means since the applicant filed his trademark in 2007, it should provide evidence for 28 countries. And I know very well the plaintiffs, the decision to which the plaintiff relied on, which is the Lint decision of the Court of Justice, which says that it would be unreasonable to require evidence for each member state. I know very well that decision, but that decision was also interpreted recently by the General Court in two cases. One was the Nanu Nana cases, and one which is even more recent is the Kit Kat case. And indeed, in that kind of cases, the General Court goes back to his previous trend, and it requires evidence for each member state, or at least that whenever there are evidence which targets just some countries, you need to provide reasonable arguments to have your evidence applicable also to the other countries based on the principle of extrapolation. And here we have like evidence just for France, Germany, Italy, Spain, UK. So out of like 28 countries, the applicant was able just to provide a few evidence. I don't really even think that the survey puts that she provided shows that her mark has acquired distinctive character, but still, even assuming that she did establish distinctive character through use in that countries, they are not enough according to our ongoing trend of our case law. So I think that the other side trademark must be declared invalid based on lack of distinctive character. So I will just spend a few words on my other arguments. I mean, I think that even in the unlikely, very unlikely event that this honorable court, sorry for my American inspiration, so will establish that the other side trademark is valid. I think that it should dismiss the other side's claims, because I think that overall the bags are different. I mean, the other side bag has like two specific spots in the middle, and my client's bag have like several spots. I think that the public will not perceive, will see them as overall dissimilar, and this will be like enough to rule out the likelihood of confusion. And then at some point, the plaintiff seems to maintain that her client's trademarks enjoys reputation, but I have seen, I don't think that she did establish that her trademark enjoys reputation in a substantial part of the European Union. So again, her trademark, her claim is completely groundless. So, and also the dissimilarity will rule out the link. So I think that this judge should dismiss her action.
Thank you. Time is running. Let's address now quickly the issue of the responsibility. Please, Maître Motet.
Yeah. So I will be quick, Madam the President. I know that the time here is running. And for the liability of both claimants, I would just refer to the fact that the trademark cannot really rely on the fact that it would have been a mere intermediary, because it's not a platform, it's really the seller of the goods, and so that obviously he is responsible for the download, for the handling of this website, and then the purchase of the bag. And again, I refer to my evidence, and I know that although there was new technique and platform electronic filing, I know that the judge like to have the paper, because usually they don't have access to the electronic platform of the clerk office. Sorry.
Off the record, this is not my strongest part. But anyway, as a litigator, I'll say something just to have the judge believe that I really believe in my case. So I think that the manufacturer is not liable because the plaintiff has not established any connection between the manufacturer and the seller. My client simply produced a bag in Italy. Giulietta sold this bag to someone, and this person decided to put the bag on the website. So there is no liability of my client for the act of infringement we are talking about today. And what about, and also, she was at least required to demonstrate that there is some relation, some connection between my Italian client and the Greek client. She cannot just say they have the same lawyer. There could be like other reasons, and you are required, based on the rules of onus probandi, to demonstrate that there is some kind of connection. And with regard to the seller, again, I think that the plaintiffs should have brought this action also against Zeus International Trademark, Zeus International Trading. So I think that Zeus is not liable for the sale of this bag in France. So,
Madam the President, I just invite you to go through the files and you will see the evidence.
Thank you. So now, what about the scope of judgment, Maître Motet?
There, I must admit that it's myself which is not really comfortable, but let's go for it. So, Madam the President, we require a pan-European injunction as well as a compensation for the damage entirely suffered in all over Europe. You are a EU trademark court, so you should be able to handle this case on a EU jurisdiction and EU scope. And I know that also it's the only way to have a cost-effective and good administration of justice. I mean, it's not reasonable to ask somebody to go in several member states and also to spend money in another country where they don't understand the language and we have to translate everything into the other language. And I know that the case law is against me, but Madam the President, I would like to address this as ARAS. I would like to show that you show some courage and take and reverse the case law.
off the record, this is really funny. Here, like my counterpart, now remembers that we have a UTM regulation with like specific rule, but when she was talking about jurisdiction, she mentioned another regulation. So, now, I go back to the case. It seems to me that the plaintiff is just trying to have this action in the place which is much more convenient, which is France, which is the place where the plaintiff is established. And okay, she may say something on the jurisdiction point, but what about the pan-European scope of the judgment that she is requiring? The UTM regulation is clearly enough on this point. Article 126 clearly states that whenever the jurisdiction of the court, of a European court, is based on the special principle of jurisdiction of the locus commissi delicti, that court has jurisdiction only over the infringement that happened in that specific country, which means no pan-European injunction, no damages covering the entire European Union. Otherwise, the defendant should have paid a lawyer either in Italy or in Greece. There is no shortcut to have a pan-European order. Thank you.
So thank you for our explanation, Maître Motet and Maître Bauta. I now close the debate, and I will render my decision pretty soon.
Thank you, Madam the President.
Thank you.
Before the hearing, I had no time to check how the Colette trademark has been registered and to see the picture of the litigious bag. But now I have all the evidence. Everything is clear in my mind.
All stand. The Paris court is in session.
You can see it. The judgment will be rendered. Judgment. Concerning jurisdiction. Under Brussels 1 recast regulation Article 7, paragraph 2, for torts matter, the criterion is based on the location where the harmful event occurred or may occur. According to EDUC ECJ case, when the intellectual property infringement occurs online, the harmful event is deemed to take place where the website is accessible. There is no need for the website to be directed towards France. In our case, Zeus.com does not target any country in particular. The language used on the website is the English language, which is considered in the business international language, easily understood by the European consumer, even in France. Website Zeus.com is accessible in France. The counterfeiting bag has been delivered in Paris, France. Therefore, the French court has jurisdiction. 1 point to the plaintiff. Concerning the validity of the 3D trademark, under Article 4 of the EU regulation, the last one, 2017, trademarks must provide signs capable of distinguishing the goods or services from those of other undertakings. Following Article 7 of the EU regulation, trademarks have to be distinctive to be valid. In our case, the shape of the Colette trademark is different from what is usually created for leather handbags. Indeed, this shape is usually used for paper bags. Due to the combination of this particular shape, the leather material, and most of all the two blue dots, this sign is distinctive per se. Concerning the infringement issue, following Article 9 of the EU regulation, to infringe a trademark, a sign has to be at least similar to the sign of the plaintiff. Concerning similarity between the goods, the Colette trademarks has been registered for goods in class 18, including bags. The little good is a bag. We have an identity between the goods. Concerning similarity between the two signs, from the auditive point of view, there is no risk of confusion between Colette Classic on one part and Giulietta on the other part. However, from a conceptual point of view, there is a chance that the public would call the Colette trademark the blue dots bag. And in this case, there would be a risk of confusion between the two signs. From the visual point of view, the only difference is the number of dots, which is insignificant since the color and the global impression is the same. The average consumer could think that the litigious bag is actually a declinaison or a variant of the Colette Classic bag. To conclude, the Giulietta bag infringes the Colette trademark. Concerning liability issue, we have a use in the course of trade without the consent of the owner of the trademark. Giulietta, the manufacturer, and Zeus.com, the seller, are both responsible for the infringement. The two companies will be condemned to pay damages. Following EDUC ECJ case, when jurisdiction is granted on the harmful event, damages can only be awarded according to the damage that have effectively been suffered on the territory of the seized court. In other words, the French jurisdiction would be just able to award damages for the prejudice suffered in France. The scope of the judgment is larger in matter of the injunction. Following DHL Express France ECJ case, An injunction can have a pan-European scope and extend the whole EU territory. On those grounds, the court hereby rules France has jurisdiction to rule. The plaintiff trademark is distinctive. The litigious bag constitutes an infringement. Zeus and Julieta must pay for the damages suffered by Colette on the French territory only. Zeus and Julieta must stop every commercial use of the litigious bag in all the EU member states. Thank you for your attention.
May I say something? It is a totally wrong decision. I'm going to appeal it within a week.
Thank you for your attendance, and when seeing the ACTA bag, we thought, oh, we may have another case for the next conference in Edinburgh. But now I will give immediately the floor to our estimate president for the ACTA Awards. Thank you very much for your attention.